The information made available via this podcast is for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this podcast or any of the email links contained within its website do not create an attorney-client relationship between Michael Dockins, Shoemaker, Lupin Kendrick, and the user or listener. The opinions expressed at or through this podcast are the opinions of the individual author and may not reflect the opinions of the Shoemaker firm or any other attorney.
Welcome back to Wrestling with the Law. Welcome to the second episode. I'm your host, Mike Dockins, the Gimmick Attorney, partner at Shoemaker, Lupin Kendrick. Hope you guys enjoyed the first episode. And for today's episode, we're going to do a topic that I know all too well. It's something I do on pretty much every day of my life for the last 16 years, intellectual property, and specifically intellectual property and how it relates to wrestling. And I'll try to weave it in there and make it as interesting as possible. Hopefully keep you awake during this, or, if you're trying to go to sleep during this, then I guess I'll try to put you to sleep. There's a lot of things that count as intellectual property, like trade secrets. Trade secrets don't really apply much in the wrestling world, so I'm not going to go into that in too much depth. Instead, I'm going to hit the big topics like patents, copyrights, trademarks, and right of publicity, all of which have direct applications to the wrestling world. Like I said, we'll go in detail on each one of those kind of in that order. It's important to note that patents and copyrights, they're covered by the U.S. Constitution. Article 1, Section 8 of the U.S. Constitution grants certain powers to Congress, and that includes the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that's, if you talk to a patent attorney or an inventor, they'll say that's the patent clause. You talk to an artist or somebody who creates creative sort of things, and they'll tell you that's the copyright clause, but it's Article 1, Section 8. So what that tells you is that patents and copyrights covered by the Constitution. Right of publicity and trademarks, meanwhile, are things that are covered by statute. So they're not guaranteed in the Constitution, but instead they are covered by statute, either state or federal, or sometimes both. Patent laws and copyright laws, there aren't state equivalents. That's something that's reserved only for the feds. It's only federal law. So you won't find, Ohio patent law or Michigan copyright law or anything like that, but you will find Ohio or Michigan or Florida trademark law and rights of publicity. And every state has their own sort of tweak or difference in those things. By and large, they're the same from state to state, but they can be and typically are different. So trademark and the right of publicity, like I said, covered by statute, covered by state things. The Lanham Act is what the trademark law is called for the federal law. There is no federal right of publicity. It's a tort. It's decided on a state by state basis. There are a few states that have very mature laws, very important laws that other states will look to kind of decide what kind of law do we want, and courts will look to and say, well, we haven't decided this before, but what do these states do? Some of those states are, you can imagine why for rights of publicity they'd be these states. New York, a lot of celebrities there. California, same. Hollywood, based there. Tennessee, with its music and country music and things like that. And of all places, my home state, Indiana. Indiana's got quite a few celebrities that were born there, but most importantly, CMG Worldwide is there. And they own and control and do a lot of licensing related to celebrities' rights of publicity. Elvis, I think their own CMG owns that and controls that. If not Elvis, I know Marilyn Monroe for sure. And I'm pretty sure James Dean, who's from Indiana. So what does this have to do with WWE? What does that have to do with wrestling? What does it have to do with AEW? Everything, really. If you ask WWE, if you've listened to them recently in the news, they'll tell you that IP is their most important asset. That's probably true. If you think about it, if they don't own their intellectual property, their trademarks, the copyrights and things like that, what do they have left? They have a library of old footage. They've got some rings. That's really it. Meanwhile, they've got the ability to license this intellectual property, both the company house brand, WWE, Worldwide Entertainment, and SmackDown and Raw and all these other trademarks and things they own. But they also have the ability to license out Roman Reigns. That's their trademark. And his likeness, which by contract, they have the right to do. And Undertaker and all these other characters in this big portfolio of characters that they have. Back in the day, back in the more territory days, wrestlers owned their own trademarks, right? And they had it And when they went from territory to territory, they took it with them and they allowed the promoters to use it for that time. They may or may not have signed over rights that allow the promoter to exploit them in videos and things like that. You might remember Jesse Ventura famously took on WWF and won because his contract did not say that WWF could use his likeness and sell, I think it was tapes, if I'm remembering correctly, tapes with his likeness from shows that he had done. Their contracts, I assure you, subsequently covered that, and they have the right to use those tapes and that footage and that thing in perpetuity. So having said all that, let's jump in. Let's talk about the different types of intellectual property. First and probably least applicable to the wrestling world is patents. So what are patents? I found in doing this for 16 years that folks often use the word patent, trademark, and copyright sort of interchangeably. My hope is that if you get nothing else from this podcast, this video, that you will take from this what the difference of a patent and a trademark and a copyright, what those differences are. They're very different. They cover very different things in very different ways. And so if you can take that away from this, then I'll consider it a win myself. So what's a patent? A patent protects inventions and it protects improvements on inventions. Often people think, well, I've got a patent, so I can do whatever I want with this invention now that I've gotten it. That's not exactly right. What a patent actually gives you is a negative right. So it gives you a right to prevent others from doing something. So what do I mean by that? You can actually own a patent and have this limited monopoly on your invention, but you can't yourself practice it. So let's take, for example, there's a patent out there, right? And a patent covers a chair and it defines the chair as a seat and 3 legs. So I've got my patent, seat and 3 legs. You come along and you say, you know what, it'd be great to add stability if we added a 4th leg. And boy, it'd be great if I didn't have to hunch over. I want a back on it. So I want to lean up against it. So your patent is going to be a seat, 4 legs, and a back. Well, your seat, 4 legs, and a back must necessarily have a seat and 3 legs. Well, that's my patent. So you can stop me and my seat and 3 legs from creating and selling a chair that has a back and a 4th leg. You can stop me from doing that, right? Negative right. That's what you have. But you yourself cannot make that chair with a seat and 4 legs and a back because to do so would infringe my patent. So it happens all the time. Folks have a patent, but they don't have the right to practice. You'll hear that a lot in inventor circles or patent attorney talk. And so you get into cross licensing, right? You'll license me your seat and 3 legs so that I can make my chair with a back and 4 legs. And you similarly can make one with a back and 4 legs. So it gives you a negative right. What do you have to be? What does your invention have to be patentable? Well, it has to be new and it has to be useful and it has to be non-obvious. The first 2 are pretty self-explanatory. New is new. It's not out there. It's something no one's ever seen before. Useful is it has some sort of utilitarian function, and non-obvious is kind of a creature of the patent law. Non-obvious, it was created by courts that said, look, if I can find this document over here, this patent or this publication or this journal that shows A and B of your invention, and then I've got this other patent over here that shows C and D of your invention, it would be obvious to combine those 2 to get A, B, C, D. So it's very much kind of a 20/20 hindsight, which used to be impermissible for the patent office to do, but now it's not. It requires a little bit of hindsight and look back. There's lots of arguments to overcome that, why something isn't obvious. Maybe one of those documents says, you absolutely must go right. And my application says, I want to go left. Well, then technically the document they cited to combine teaches away from the premise, teaches away from my invention. So it wouldn't be obvious. In fact, somebody looking at the 2 documents wouldn't combine them. Lots of ways to get around it, but those are the 3 primary simplistic factors of how you have something that is patentable: new, useful, and non-obvious. There's different ways to protect things. There's different sorts of patents and patent applications. One is called a provisional patent application. A provisional patent application is very informal. Quite literally, I could write on a napkin or a piece of paper sitting right here what my invention is, put it in an envelope with a stamp, send it off to the patent office, and I'm filed. It's like I said, it's very informal. It's not going to be looked at. They're just going to rubber stamp. They're going to give it a serial number. They're going to give it a filing date. And the patent office says, congratulations, your patent pending. That's the benefit. Your patent pending. You can do it very quickly. So since it's kind of a race to the patent office, you have to be the first inventor to file. Oftentimes, it's a quick and dirty way to get something on file while you're still developing or while you're figuring out your business plan or manufacturing or whatever it is. A provisional application is good for a year and only good for a year. So at the end of that year, you can file a full-blown application, a non-provisional technically, but you'll hear people call them utility applications. And once you get there, now you're formal. Now you've got the formal, flowery, or confusing engineering speak, technical speak, patent applications and patent language. And that's when the process actually gets started. The provisional is not looked at by the patent office at all. Truly, they just take it, stamp it, file it away. You've got a year to figure out what you want to do. So a utility application, and we'll pop one up here on the screen, that's actually a Hasbro utility patent application. That Hasbro application covers Hulk Hogan's Gorilla Press Slam action figure, if you remember the original Hasbro line of WWF figures. And hopefully through the miracles of editing and all of that, we'll kind of flip through and you can see the different pages. There's actually some pretty cool drawings. Those are patent drawings, right? You notice the reference numbers and lines and things like that. But this utility patent is covering, and I'll breeze through it, even though it'll pop up on the screen. The claims, that's the important part of the patent, cover a main body with some other things, but a first arm portion, a first hand portion, a second arm portion, a second hand portion, and a means for biasing first, second arm portion and first and second arm portions. And then it talks about how the arms rotate and pivot forward and downward and things like that. Essentially, it's describing how the action does the Hogan Gorilla Press Slam. So that's what the patent is covering, how it's all put together, how the pieces interrelate, and what it does. That a utility patent is good for 20 years. It's good for the calculation is 20 years from the date you file it. Typically, when you file an application, it's going to take a couple years for it to get through the process before you get an issued patent. But any delays caused by the USPTO, you get back at the end. There's something called PTA, patent term adjustment. And if you ever see the front of current day patents, they've been doing this for a while, but some of the older ones don't show it. It'll show the patent term adjustment. It'll say, yeah, it's 20 years from the earliest filing date, but because of us, because of the USPTO, because we were so slow, we're going to give you back 1 day, 15 days, 150 days. I've seen years and years added on because of USPTO delay. The thing about a utility patent is because it gives you a limited monopoly, it gives you that limited right to prevent others from doing something, you have to pay maintenance fees. So you've got the cost of getting the patent, and then at 3.5 years after it's been issued, you have to pay the first maintenance fee. And that's the government saying, hey, we want another cut. We want you to pay to keep this right, to keep this monopoly. Presumably, you're making a little bit of money on this. You're exploiting it. And so because we, the government, by virtue of the Constitution, have given you the right to have this monopoly, pay up. And they do that 3.5 years, and then that number doubles. At 7.5 years, you pay your second maintenance fee. Same kind of reasoning. Presumably, if you're still using it, you're still exploiting it, you're 7.5 years in, you're making more money, you can afford it. And we're talking hundreds of dollars, not thousands and thousands of dollars. Then, of course, there's a third maintenance fee, and that happens at 11.5 years. Same thing, price goes up again. This one is $1,000+. But again, the idea is if you are using this and exploiting this and taking advantage of this monopoly, you should pay for that right. Once you pay that third maintenance fee, your patent's good for the full 20 years. You don't have to pay anything else. If at any point you don't pay the maintenance fee, your patent goes abandoned. It becomes then public domain. The idea behind patents is we want you, the citizenry, to disclose your inventions to us because it's going to make us all better. It's going to make the world better. Not only have you solved some problem that your patent covered, but you have also gotten other people to say, man, I can't do this. I can't practice this invention. Someone has a patent. I'm going to figure out a way to do it myself. I'm going to design around it. I'm going to find another solution for the same problem. And so you've spurred people on to try new things, maybe even improve on your invention. And you're promoting the arts and sciences, right? Just like the Constitution said. And if you're not using it, you're not exploiting it, you're not paying the fee, then it goes to the public domain that much sooner for anyone and everyone to use. The types of things that can be covered by a utility patent include devices, methods of making things, methods of using things, Potentially, it's complicated. I won't get into it, but business methods and computer algorithms and things like that. There are some plant patents that you can get for non-naturally occurring plants. Those are the types of things that are covered by a utility patent. Another type of patent, and again, this one applies directly to wrestling, is design patents. So a design patent is it's a type of patent that only covers ornamental appearance, ornamental features. So it's not covering how things are put together. It's not covering how they're used or how methods of using or things like that. It's merely what it looks like, the ornamental features. So we're not talking about, hey, I've got this pitcher here, and this pitcher has a wall or 4 walls and a bottom, and it's able to hold fluid, and it has a handle, right? That would be the utility patent that's covering that. Walls, bottom, handle, spout, holds water. The design patent would say, you know what? I've got this pitcher, but it looks really cool. It looks like Rikishi. And so it has a big ass, and it's got, long blonde hair, and the spout is coming out of the top of his part and this sort of thing. There's a handle on his back. So it's not that it's holding water. It's not that it has walls necessarily or bottom. It's that it has those particular walls that look just like that. That's what a design patent covers. We're going to pop another one up here. This one is from Lucasfilm. This is the design patent filed on the original Boba Fett action figure. Remember Lucasfilm, because that's going to come up later. I've got a pretty fun story. At least I think it's fun, related to Lucasfilm. But you can see through these things, the artwork, the drawings for design patent are pretty darn cool. A lot of people will take these and reproduce them and put them on cool paper or on metal or things like that. And it's kind of hangable art. It's kind of technical art. But you'll see in a design patent, you've got a bunch of different views, because a design patent doesn't have the flowery patent language. Your claims, your invention are the views. They are the figures. So usually you're going to have a front figure, a back figure, a right figure, a left figure, a figure from the top and a figure from the bottom. And when I say figure, I mean drawing, not action figure. And then maybe a perspective. So one that's kind of at an angle to give a little bit of depth to it. But you're going to have top, bottom, front, back, left, right, and perspective is usually what you're going to have in a design patent case. A design patent's good for 15 years. There are no maintenance fees. So once you've got it, you've got it. It's pretty inexpensive to get relative to a utility patent, of course. And it's no maintenance at all. Once you've got it for 15 years. The problem is it only covers ornamental features, right? So there's lots of action figure design patents. There's lots of doll design patents and things like that. All you have to do is make some changes, a few changes, and you've gotten around it. So it doesn't take much to get around it, but it has value. It can absolutely prevent somebody from making an exact knockoff or a very, very similar knockoff. Patents are territorial. That's an important thing to remember. They're territorial. So a U.S. patent is good only in the U.S. A Canadian patent is only good in Canada. So anywhere that you want to protect your patent rights, you have to file. So if you don't file in Mexico and you're in the U.S. and you're in Canada, and somebody in Mexico, some manufacturer sees your invention and says, oh man, that'd be really cool to make and sell here. Absolutely nothing you can do about it. You can prevent it from being brought into the US because the patent laws cover that, but you can't stop them from making and selling in Mexico. So typically I advise clients, well, you want to go where you are. You want to go where you're going to be soon. Maybe you want to go where your competition is, so that they can't be making it where they are. You keep an advantage there. And maybe you go to places that are big import and export places. China, for example, if there's lots of knockoffs, yes, you can stop them from coming in, but wouldn't it be great if you stopped them there so that they can't then export it from China to other countries where they know you're not covered? Fees are required in each place. Translations are required in each place. So the patent process and going to foreign countries is a very expensive venture. I get asked all the time, is there an international patent? Is there something I can do to cover the whole world? And the answer is no. There's something called a PCT application, stands for Patent Cooperation Treaty. All the PCT application does is buy you time. So it buys you the right to defer a decision on what countries you want to go into. Get you 18 months. Again, it's expensive. It's a few grand for the filing fee, but sometimes you need time, right? Is this product going to launch? Is it going to do well? Do the people want it? So you might not know early on when you have to make that decision about foreign filings where you want to go. So it might be worth spending the money, file the PCT application, and find out, what happens over the next year and a half. The process, I kind of referenced this earlier, the application process in the USPTOs, you file it, it's going to sit there a while. They're pretty slow. It's probably going to take a couple years, but eventually it's going to be reviewed, and the examiner is going to issue an office action rejecting the application. Then you have back and forth. This is what we call patent prosecution. You're prosecuting the patent before the patent office. You have some back and forth, and hopefully after a little bit of back and forth, because there's cost associated with all of it, eventually you get the patent issued. There's fees along the way. The government always wants the cut. The lawyers who are doing the work going to get a cut. Some of you noticed in my bio after last episode, I have an engineering degree. Well, to be a patent attorney, you have to have an engineering degree or a science degree. So not anybody and everybody can be a patent attorney. There has to be math, science, physics, applied optics, or engineering or something like that as your major, as your degree. Because I have a chemical engineering degree, I'm a patent attorney. A couple things to think about and beware of when you've got an invention. Whenever you have something you think, hey, this could be marketable, I could make money on this, I can get a patent on this. You got to be aware of these two things. One, first inventor to file wins. So it's kind of a race to the patent office. There might be somebody, as unlikely as it seems, who's working on the same kind of product or finding a solution for the same kind of problem that you are at the same time. Never met you, never seen a presentation, anything like that. And if they beat you to the patent office, even if you came up with the idea first, if they beat you there, they get the patent. So you don't want to drag your feet on it. But more importantly, something about disclosure. If you disclose your invention, or if you offer it for sale in the United States, you start a clock, and that clock runs for 1 year. And if you don't file up your application within that 1 year, you lose the right to file a patent application. So it's the 1 year disclosure, right? And it's public disclosure. And people ask all the time, oh, I just talked about it with my neighbors. I was at the homeowners association meeting. That's public disclosure. It's not a matter of, hey, it was on a podium and in front of this whole seminar and there were 10,000 people there. No, just talking to your neighbor about it. That's a public disclosure. Talking to someone with a non-disclosure or some confidentiality provision. So for example, when I have clients come to me and they start talking to me, even if they don't come on as a client, there's a confidentiality that ties to what they tell me as a prospective client. So if there's confidentiality there, there's an NDA in place, something like that, that's not a public disclosure. That doesn't count. That's the US, right? And the US is very different from the rest of the world. The rest of the world doesn't give you that 1 year clock. The rest of the world is what we would call absolute novelty. So as soon as you disclose it, as soon as you offer it for sale, publicly disclose it and offer it for sale, you lose the right to file. So you can't be talking about it. And when you do, you should have it covered by non-disclosure. Otherwise, you might lose the right to file it in foreign countries. Infringement, right? So you've got this patent, you've got something that's protectable. What happens now? Well, it requires some analysis. It's kind of complicated, but what you're looking at is the claims of the patent. If you've ever seen a patent application, which you should have now, because we showed you the Hulk Hogan action figure and the Gorilla Press Slam, the very end of the patent has a numbered, well, in this case, it has one claim and a numbered sentence. And it starts with what is claimed is a wrestler character figure comprising, and then it's got A, B, C, D, E, F, G, all the different parts. That is the word's description of your invention. That is the enforceable thing. Now, all the words that are in the claim are defined by or interpreted in view of the rest of the disclosure of the patent. They're also interpreted in view of all the things you said to the patent office during prosecution. So you can't just look at that claim and look at that language and think, oh, I know what that means. Well, no, because each word in there is defined by the disclosure of the patent application. It's further defined by the arguments you made to the patent examiner during prosecution. So like I said, it can be kind of complicated, but so long as somebody is infringing or practicing each and every element of your claims, they're infringing. There's also something called the doctrine of equivalence. So with every rule, there's an exception, right? Just like the English language, where somebody maybe isn't infringing each and every element exactly, but they're doing the same thing in the same way for the same purpose. So a simplified way to think about it would be, well, this chair, right? How am I holding the legs on? And let's say my patent says I'm holding it on with nails. And you come along, haha, I'm not going to use nails. I'm going to use screws. Doctrine of equivalence, probably still infringing, right? It's still a mechanical means for attaching the elements together. So it's probably still infringement. So let's say somebody else comes along and says, well, I'm going to use glue. I'm going to glue the legs onto the chair. That might still be doctrinal equivalence. At least it's a chemical, it's a bonding thing, but it could be argued that it's a physical thing, mechanical, if you will, and it might be infringing. But then what if somebody else comes along and says, well, I'm going to use sonic welding, right? I'm going to use sonic technology to kind of melt the materials together. That's very different, right? That's very different from a nail or a screw or glue, where you're using some kind of third party, third thing that's helping connect all these things. Probably not doctrine of equivalence, but somebody then is successfully designed around your patent. So that's infringement. As far as best practices for patents are concerned, document inventions, right? Keep a notebook, keep things logged. That used to be very, very, very important, but the law changed in 2013 or 14. It's still important because if you own a business and you have this prior use that maybe you didn't patent it, but you've been using it for a long time, somebody else comes along and they patent it because what you were doing is secret and wasn't publicly known, that sort of thing, wasn't prior art to them. Then you've got this prior user defense and you've got it documented. Hey, here's the documentation. We had somebody disclose it to us. We started using it in our manufacturing and using it in our plants and all this. Therefore, we can't be found to be infringing. So it's important to document. And if you own a business, employment agreements are an important thing, right? Employment agreement will typically say, hey, you work for me in whatever capacity. Some will say this only for engineers and design types and marketing types, but whatever intellectual property you create on company time or using company resources, we own it and you automatically assign it to us, right? You agree hereby based on this employment agreement that it's automatically assigned. That way you're not chasing down some disgruntled employee who's mad because they got fired or mad because they felt mistreated, who then refuses to sign some documents that show that the company owns it. So those are some pretty important best practices. And that's kind of patents in a nutshell. Moving on to copyrights. Copyright, again, very different thing from a patent. What is a copyright? It protects the works of authors. And to be a work of authorship, there's a standard. And the standard is it has to have a modicum of creativity. Well, so what the hell does that mean? A modicum of creativity. I'll tell you what's not creative. I'll tell you what the law says is not creative. Having a phone book that alphabetizes last names. How else would you do it, right? That's not a copyright protectable thing. Now, when you've got yellow pages, if any of you are old enough to remember what those look like, and how those are organized with all the graphics and things like that, that's potentially protectable. If you create a phone book that was based on hair color, here's all the blondes in my city and all the redheads and all the bald people, that's probably protectable because there's some creativity that went into how it was organized. But there has to be a modicum of creativity, pretty low threshold. When you own a copyright, what does it grant you? Well, it grants you a bundle of rights, and these rights can transfer together if you sell your copyright or assign your copyright, or they can be licensed or sold separately, right? So when you have a copyright, you get a bundle of rights. That bundle of rights is the right to copy, the right to reproduce, the right to distribute, the right to perform, the right to display, and the right to control derivative works. Now, right to display, what does that mean? Oftentimes people will buy a painting or buy a sculpture or something like that. You have the right to own that, right? You own the thing. You do not own the copyright. So just because I bought a Picasso doesn't mean I can make posters and postcards and charge people to come see it. If I own a DVD, right? If I own a DVD or Blu-ray of a movie, I own the thing. I don't own the copyright. So when you own a DVD and you own a Blu-ray, you have the right to watch it in your house. You have the right to watch it with your family. You have the right to watch it with close friends, perhaps. You do not have the right to take that DVD and go to your kid's school or your church or wherever and let people watch it or let people, pay to come see it. That's kind of a display right. And that's what the copyright owner holds. And you see lawsuits about this sometimes. Definitely you hear about like ASCAP and BMI, which are music rights folks, and they will go from bar to bar or store to store, and they'll have somebody sitting there with a clipboard and listening to the music that's playing. And here's the song that played, and here's a song that played, and here's these 10 songs that played, and I'm going to go and see if you had a license. If you had a license to play these songs. If you don't, you get a nasty letter from them, or they'll sue you because you didn't have the right. Even if you own the CD, I own the Pearl Jam CD. I have the right to play the Pearl Jam CD in my store. You don't. You don't at all. You own the CD. You have the right to use it for your personal uses, not for public performances, public displays, things like this. So that's an important thing. Derivative works. This is the fun one. This is one I really like. It has good fun stories. So what is a derivative work? A derivative work is any work that is created based on the original work. So the example I like to give is Star Wars, right? The original work is a movie or screenplays or whatever. And the derivative works are action figures or posters, postcards, pillows, bed sheets. Those are all derivative works that took the base story. It took the Star Wars story, the characters and all the things that are protected by copyright in the story, and it created these spin-off sort of subsequent works. The reason I like the story is because George Lucas is a genius. And I don't say that because he made movies that I like and that I've sapped my kids into liking as well. But because at one point, Fox said, this Star Wars movie is going to flop. It's terrible. It's not going to do well. No sci-fi has done well. It's not a thing. And boy, this is going to suck. And they were balking at finishing the movie. I think it might've been over budget or whatever, but they had no faith in it whatsoever. And so Fox went to George Lucas and they were going to can the whole thing. And he said, whoa. What if we do this? I will forego $500,000 in my directing fees. I will give back $500,000. And all I want in return is the licensing rights, the rights to derivative works. And Fox, what a sucker. Yep, you can have it. Well, if you think about it at the time, I think 77's when A New Hope came out, action figures based on movies and things like that weren't a thing, right? It just wasn't a big popular thing that they did a lot of. And so Fox thought, boy, we won the day on this and we saved ourselves $500,000. And as the picture will pop up here, Lucas had, for a flat fee, I think it was $100,000, sold the rights to Kenner to make these toys. It was the licensing fee anyway. And Kenner went and sold the original packs and it did so well. They weren't prepared for what was going to happen. So you got these certificates that, you could redeem later. So parents were going at Christmas, buying the certificate, giving the certificate for their kid, then mailing it in later, getting the action figures. That first year, they sold 100 million toys. In the year 2013, billions of dollars were made off of Star Wars toys, and there wasn't even a movie that year. So now you know how Lucas became a billionaire. He traded $500,000 in a franchise and derivative works and licensing fees that Fox thought were useless, and he became a billionaire, all because of derivative works. Another story I like, and it tells you about some clever lawyering, is about Midnight in the Garden of Good and Evil. And we'll have a picture pop up here. And if you see this picture, you'll see that it's the movie poster, right? And there's a statue in the middle, and there's some moonlight shining down on the statue. They use this photograph that they had found, that they, being the studio or movie maker, found this photo, said, man, we're doing this movie based on this book, and this is great. We love this picture. Movie poster. Well, the photographer said, nay, movie studio, I'm going to stop this movie from coming out. You stole my photo. You made a derivative work of my photo, a movie poster, and you're using it and promoting and so on and so forth. You've stolen my copyright. I'm going to stop this movie from coming out. Pay up. I want a king's ransom for this. And so the movie studio obviously kind of panicked and thought, man, we put all this money into advertising. We're going to lose all this stuff. What are we going to do? Well, someone cleverly said, hold on. It's been a couple weeks, came back, sent a letter to the photographer and said, yeah, you know what? You're right. We did take your photo and we did make a movie poster based off of it. Interestingly, your photo is a derivative work of a statue. And we found the author of the statue and we bought his copyright interest. So you have now made a derivative work of our statue. So actually, we're suing you. And needless to say, the movie came out on time and everything worked out for the movie studio. But that's what a derivative work is. It's a work that's spun off from sequels. Sequels are derivative works, spun off from original works of art or copyrightable works. So what are the types of things that can be copyrighted? There's a lot of things. Written text. We're not talking about short phrases or one word or two words. That's covered by trademark. Photos or paintings, three-dimensional arts like, I don't know, championship belts. Those are three-dimensional sculptures, essentially. And all the bootleg belts that are out there are actually infringing because they've infringed upon somebody's copyrights to be made. Dance routines, why not a wrestling match, right? If somebody wanted to write down and figure out the routine of, say, Ricky the Dragon Steamboat and Ric Flair 1, 2, or 3, the trilogy of famous matches, and then you could protect that. And if somebody else comes along and says, well, I'm going to recreate that match, and it's going to be, Daniel Bryan and whoever, Roman Reigns, are going to do this. Well, nah, they wouldn't be able to. To my knowledge, nobody's done that. And I don't know why you would necessarily want to copy a match exactly the same or close to the same, but it could be protected. It could be stopped. Music's covered by copyright, both the sheet music with the notes and things like that, but also the lyrics, the performance of music. So, Frank Sinatra's rendition of this versus Michael Bublé's rendition of this. The performance itself is protectable by copyright. Videos, TVs, movies, software code. Those are all different things that are covered by and protected by copyright, which again is protected by the Constitution. What copyright protects? This is important. Copyright protects the expression of an idea, not the idea itself, the expression of the idea. So if I came to you and I said, man, I've got a great idea. My great idea is this guy from this family falls in love with this girl from this other family. And boy, those families do not like each other. They hate each other. But the boy and girl fall in love. What did I just describe to you? Most of you are probably going to say, Romeo and Juliet. Well, no, maybe I wasn't talking about that. Maybe I was talking about West Side Story. And it's not blood family. It's, gangs. It's sharks and jets. And it happens in New York. Or I could say, no, I wasn't talking about either of those things, guys. I was actually talking about Murphy and Rey Mysterio's daughter, right? Two different factions that hated each other, but they had this love thing going on. So that's the idea. The idea is what I described to you. What's copyright protectable is that it happened in Italy and there's sword fighting and a fake poisoning at the end, but then it was a real poisoning and a suicide. Or that it happened in New York and it's gangs and there's songs and dance and all these things around it. Or that it happened in wrestling and it's this legacy. It's a gang sort of family with Murphy and Rey Mysterio and the Mysterio family. So it covers the expression of ideas, not ideas. How many paintings of sunflowers have you seen? How many pictures of whales cresting out of the water have you seen? A million, right? Tons of them. And it's all about the color palette you used, where the sunlight hits it, the shading, the color of the vase, all these different things. That is the expression of the idea. That is what is protected. So I can go and do my own wrestling storyline that is somebody in one faction falling in love with somebody in another faction, and that's okay because that's the idea. It's the details around that idea and how we work it out. That's what's actually being protected. Copyright, it's important to note, is something that you get that's granted immediately upon creation. So it's not registration based, it's creation based. So if I grabbed a piece of paper, sketched up, what I think Braun Strowman looks like, my drawing of Braun Strowman is copyright protected. I just fixed it on a piece of paper. If I draw something on the drywall here in my office, I've got copyright protection in that. As soon as it's created, as soon as it's in a fixed medium, which can be on my computer, it can be on a piece of paper, it can be on the drywall. As soon as it's created, I've got copyright in it. The default is that authors are the owners. That can be dealt with by employment agreement and work for hire and all these sorts of things that can be immediately assigned, or there are circumstances, for example, employees who are employed to create copy, to write stories, pamphlets, brochures, develop websites, that sort of thing. That's going to not be that person as the author. It's going to be the company as the author. It's going to be a corporate author. And that's important because copyright protection lasts. It's very flexible. It's also very complicated because the copyright laws have changed a lot. They've changed a lot over time. For example, I want to say it was 98 or 99. Sonny Bono took up the cause of Disney because Mickey was going to join the public domain. And, where there's money, there's the ability to get the law changed. And so they extended the copyright and changed it so that Mickey Mouse could stay still within the purview of Disney's ownership. But they changed it then to the life of the author plus 70 years, which you have to look at as when the work was created and what the law was at the time, as to what will apply and how it will apply, and if whatever subsequent law changes were in any way kind of backdated and fixed that. It's like I said, it's convoluted, but generally speaking, right now, it's the life of the author plus 70 years. That's how long the copyright interest lasts. So if I've got authorship in something and I live for another 60 years, well, then there's 130 years left in my copyright. If I die tomorrow, then 70 years from tomorrow. That's the life of my copyright. If you're a corporate author, it's 100 years. So there's no life plus anything. It's just 100 years. When you assign copyrights, it's important that those things are in writing. They have to be in writing. So there's not really oral assignments. It all must be documented. So it's important to have that documented. Registration, I mentioned, was not important to whether or not a copyright existed. That's true. But registration is important, and it got a lot more important about 2 years ago, because it used to be you could have a work, not register it. Somebody infringes it, no big deal. I'm going to file an application for registration, and I'm going to sue them the next day. And the court said that was fine. An application pending, good enough. We're fine with that. Well, the law changed, and the law says, nah, for you to be in court, be in federal court, because this is federal law covered by the Constitution, you have to have a registration. So you have to go through that process before you can even sue. It's also important because by getting a registration, if you get it in a timely fashion, you get a special type of damages. You get statutory damages, not to be confused with actual damages. Hey, I was selling 5,000. Now I'm selling 2,000. I've been damaged by 3,000. Here's the calculation. Or by a disgorgement of profits from the other side. Hey, they profited by selling 5,000. I want all their profits. Well, then the other side, the defendant, gets the ability to say, well, we put in R&D and marketing and all these things that will defray the cost and make their profits lower. Statutory damages, the law says, if we find infringement, you're going to get somewhere between $750,000 and $35,000 per work infringed. So if I have to send a cease and desist letter and you made 10 bootleg belts of what I own, what I have protected, that's 10 times potentially 35,000. That's no laughing matter. If it was found to be an willful infringement, intentional infringement, it can be up to $150,000 per work infringed. So now we're talking 150,000 times 10. Those are big numbers. Those are scary numbers, and will really get people's attention. You're also likely going to get attorney's fees. So it's kind of a no-lose situation if the timing of your registration was proper and if there's a finding of infringement. Gives you some really big hammers to swing and some really big leverage. Infringing a copyright. How do you do it? What does that mean? Well, infringement is looking at someone's access to the copyrighted work and the similarity of the works. So the more access you have means the less similar it has to be. The less access you have, the more similar it has to be able to. It's a sliding scale. It's a graph. Won't bore you with that image, but it's very much fact intensive. It's something you got to look at to really determine whether or not there's infringement. It's kind of an ordinary observer test. Basically, as your attorney, I'm going to go up to the jury and I'm going to hold up my work and I'm going to hold up your work and I'm going to say, do these look similar? If they do, that's infringement. You need to fine for my client. Defenses. You hear a lot of, oh, this is fair use. My use doesn't count as infringement. It's fair use. Fair use is very specific. It's very fact intensive. And anybody who says that something is fair use, just like this, is doing a disservice, because it really takes some fact finding and some analysis. But generally speaking, defense based on fair use is going to look at four things. It's going to look at the purpose and character of the use. So is it commercial? Is it educational? Is it done for parody, which is kind of covered by the First Amendment? The nature of the work, that's the next thing we're going to look at. Is it an artistic thing, or is it kind of a fact-based thing? So is it fiction or is it nonfiction? That's something that the courts are going to look at. The amount copied. So some people will say, oh, well, I only copied, this teeny tiny amount. So that's fair use. And you're not harmed by it because I only took out some small portion. Well, that's just not true. You have to look at what was taken and how it was taken. So, for example, if Harry Potter, I don't remember which book it was, 5 or 6 came out. Spoiler alert, if you haven't read these, plug your ears. But Dumbledore dies, right? And so if I'm doing a book review before it comes out or as it comes out, and I reproduce 3 sentences, and those 3 sentences are talking about Dumbledore being killed by Snape, falling off the tower, That's pretty important, right? That's a very important part of what was taken and kind of ruins the whole story, hence the spoiler alert. And so taking that could result in a finding of infringement and no fair use. Meanwhile, that same book, I might be able to do my review and reproduce the entire first chapter and give nothing away, nothing of importance, but it's one chapter out of however many there are, 45, and it doesn't give anything away. So that might be okay. There's no magic number. There's no magic percentage. It's all kind of weighed versus all the other factors for fair use as to whether or not it's going to be infringing. Next factor is the effect on the author's market. So if you're doing something in a way that harms the author in some way and their rights in the copyright bundle, that's going to weigh against you for fair use. No one thing is determinative, and just because you lose one factor doesn't mean you lose the case. Again, it's very fact intensive. Other factors, things that can weigh in your favor, attribution, right? And so people say, well, I gave credit to the author, to the writer, to the musician, so it's fine. I mean, it's something that's important. It's something that can kind of weigh in your favor. But again, there's a totality of things that have to be looked at. Having the attribution is good. It could help you. Not having it could hurt you, but it's not going to win you the day necessarily. So those are just things that people ask about fair use. And it depends, right? It's a very lawyerly, wishy-washy answer, but that's the answer. It depends whether or not it's going to count. So that's the long and short on copyright. Now moving on to trademarks, right? Not covered by the Constitution. It is covered by the federal laws and Lanham Acts, but also state laws. Each state law varies. So what's a trademark? A trademark is any word, name, symbol, or device, or combination of those things that identifies a source of goods or services. So in short, a trademark is a source identifier. That's what it is. A source identifier. I can look at a swoosh on a t-shirt. I can look at a swoosh on some shoes, and I will know where that came from. And that could be a good thing or a bad thing, right? I don't like that stuff. They use small Asian children in sweatshops to make their stuff. I don't like them. Or, hey, those guys in the Pacific Northwest, and yeah, they use sweatshops, but that's okay. I like it. It's good quality. It holds up. Michael Jordan deals with them. I want to deal with them too. So it's a source identifier. But it's any word, name, symbol, device, or combination that identifies the source of goods or services and distinguishes them from the others, from your competition. A trademark can be a word, it can be a logo, it can be a smell, it can be a product design, it can be a color, or it can be product packaging. So logos, words, that all makes sense, right? The swoosh, Nike, those are words. That's a logo. It can be a combination of those. Smells. The first smell trademark registration was a brand of thread that had the smell of plumeria blossoms. And the smell was found has nothing to do with the function of the thread. If it had to have that smell, if it somehow was important to the function of it, then it wouldn't have been able to be registered. It didn't, so you got a registration. I believe the smell of Play-Doh is a registered trademark. So if somebody else is making moldable clays and things like that, it cannot have that same smell because that will be confusingly similar and that will be found to be trademark infringement, believe it or not. Product design. Think about a Coca-Cola bottle, right? That is the contour sides and kind of the ribs and things like that. That's a product design. So you can protect how your product looks so long as it's not functional. What those ornamental features isn't functional, that can be protected. It's trade dress. You might have heard that language. Colors. Nitrile gloves, non-latex gloves, the ones that are purple. That purple has nothing to do with the functionality of those non-latex gloves. So purple is actually protected for non-latex gloves by a company. I don't want to say it's the most famous. It's most famous because where I live, but insulation, pink insulation made by Owens Corning here in Toledo. Their headquarters was here and it all came from here originally. The pink insulation, it was found. Pink had nothing to do with the properties of the insulation, but it made it stand out. When people see pink insulation from across a Home Depot or across Menards or across Lowe's, they're going to know that's Owens Corning. They know the source. Even if they don't know Owens Corning by name, they're going to know the source of the goods. Pink is the trademark. Non-Owens Corning insulation is typically, at least the stuff I've seen around here, is tan, right? And tan, again, has nothing to do with it. It has no functionality. You don't have a higher or lower R value, insulative value based on the color. So color is a trademark. Product packaging, now we're talking about not the product itself, maybe the container it comes in. So, stuffed animals like pound puppies and things like that from when I was a kid anyway, had a distinct kind of look to it. That box, that container could have been protected by trademark registration. I don't know if it was or not. When it comes to wrestling, what is a trademark? How can it be protected? As I think most of you know, I've got quite a few wrestling clients and do a lot of this work for them. Ring names, slogans, hand gestures, two that people sleep on. And I did one recently for a client, face paint, right? If you come out with certain face paint on, and WWE has it for the Ultimate Warrior, a certain look to the face paint, you can protect that. You can register that as a trademark so that nobody else can use that similar face paint related to wrestling. Also ring gear, right? If you have the particular look of ring gear, think like the masks, think Rey Mysterio's masks or Juventud or somebody like that. Those masks, that look, that ring gear could be protected by trademark registration. So what's important with trademarks, right? Selecting it, how you select it, what you pick. And I cannot urge folks enough, not just wrestlers, all of my clients that get trademarks, to do a clearance search first. You want to make sure to the best of your ability that you have the right to use and register your trademark. Those are two very different things. You may have the right to register and not use. You may have the right to use, but you can't get it registered because there's something blocking you for some reason. So the clearance search is kind of like an insurance policy. It might turn up nothing and there's no reason to have done it except peace of mind. But to me, it's worth the peace of mind. But you can have a trademark. You have trademark rights. You have what's called a common law trademark if you are using it without the benefit of registration. If you do that, that's fine, but you only have rights where you're using. So if you're selling something and you're only selling it in New York and Vermont and New Hampshire, that's where you have rights. You don't have rights anywhere else. You don't have rights in Florida. So if somebody uses the same trademark doing the same stuff and they're doing it in Florida, probably can't stop them because you're not in Florida. You only have common law rights. But if you get a federal registration, well, now that's a different story because a federal registration will give you nationwide rights. It will give you nationwide notice to anyone else, gets you in the federal courts and gives you the right to use the Circle C, or Circle R. Circle C is the copyright notice, free to use, don't have to have a registration. Circle R is what you have and what you use for trademarks when they are registered. If they're not registered, you'll use the little TM. So look at your products, look at service pamphlets, repair trucks and things like that. If you see a Circle R, they have a trademark registration of some sort, or Circle S for a service mark. If they have the TM, what they're saying is, hey, we have some rights in this. We think we have a trademark in this. We don't have it registered. So we only got it protected where we're using it. So wherever you're seeing it, that's where we have rights. So that's the difference between the TM and the Circle R, Circle S, if you've ever seen those. When it comes to trademarks, what's most important is the first to use. The first to use a trademark has priority. As a trademark owner, registration or otherwise, you have a duty to police it. And so long as you police it and protect it, policing it does not mean you have to sue everybody and go after everybody, but you can't just sit around and let people knock off your trademark, use your trademark, and do nothing to protect it and prevent it. But so long as you keep your trademark active, so long as you continue to use it, so long as you police it, you can keep it forever. So Coca-Cola has trademarks that go back decades, over a century, because they've used them continuously in commerce on goods or services for that long. So you can keep it forever, unlike a patent, which is a limited monopoly, unlike copyright, which is a limited monopoly or limited protection. But trademarks can be good forever, so long as they're used. When you file a trademark application, there's two ways to do it. You can do one based on actual use. Hey, I've been using this trademark since last month, since 7 years ago, whatever. You show use, you prove it, and it goes through the process. Or you can say, hey, I'm not using it yet, but I've got this business, I've got this pharmaceutical drug, I've got something that I intend to call this name, to brand it this way. We're just not doing it yet. We haven't sold it yet, but we're gonna. And we want to start the registration process. It's an intent to use or an ITU application. The process is exactly the same for both. It's just that an ITU application, when you get to the end, you eventually have to prove use or get extensions until you can prove use. The process is pretty simple, very much like the patent process, but faster and less expensive. You're going to file an application. The trademark office isn't going to touch it for about 3 months. At 3 months, the examining attorney in the trademark office is going to pick it up. They're going to do a search of their records. If you've done a search first, then you've already done some of that due diligence and should know what's coming up, what to expect. If you get a rejection, there'll be some back and forth. Hey, this trademark that you cited as being confusingly similar isn't. It's not similar. You shouldn't have cited that, and you're wrong, and here's why. Or they'll say it's descriptive, right? A descriptive trademark can't be, it isn't as protectable. There's a hierarchy of trademarks. First, you want kind of a coined term. So Xerox, we all know what that is now, not a real word, right? That's a word that was created for printers and things like that. That's your strongest trademark. It's your strongest because it's a made up word and it's not a word that's in the lexicon and you've created it. It's difficult and the marketing people hate it because it tells you nothing about the product itself, right? It's not descriptive. It's not suggestive or anything like that. And so you have to do the work to build up the goodwill in that trademark. But once you got it, and you've got the strongest mark you can have. The next strongest, and still pretty strong, even though it's not a coined term, is an arbitrary mark. So you take some word that exists but has nothing at all to do with your product and use that as your brand. Apple is a pretty good example of that, right? You hear Apple, most of us probably would think, well, you're talking about the fruit, or you're talking about the phones and AirPods and so on and so forth, and iTunes and music players and so forth. I don't know. But they've built up a strong brand in Apple. That's an arbitrary trademark. A suggestive trademark is the next step down. It is suggestive of the goods or services. So it's not descriptive, but it's suggestive. So Tide for detergent. I think Tide was actually found to be descriptive, which is nonsense. But as an example, Tide for detergent, Tide, water, cleaning, soap. Okay. It took me a couple steps to get there. It took some thinking, but it's suggestive, right? It's suggestive possibly of detergent versus descriptive. Descriptive is it describes a feature, function, use, characteristic, quality, ingredients. I think I'm missing one of the goods or services. So there's a brand Loctite for locks. Well, that's pretty descriptive, right? And that's what marketing people love. The marketing folks hate the trademark attorneys and vice versa, because the marketing folks want a trademark that describes the goods or services so you don't have to educate the public. When I hear Loctite, that's probably a brand of locks, right? It's pretty straightforward. It's pretty descriptive. But those are the hardest to protect because descriptive trademarks can be used in normal sentences and not in a trademark fashion. It's descriptive fair use, and there's nothing Loctite can do about it. I have Master Lock. I'm writing copy for my advertisements, and I'll use Master Locks. They lock tight. They can't stop me because I'm describing what my locks do. They lock tightly, right? So nothing they can do. So you want to stay away from descriptive trademarks. The last class of trademarks, it's not really a trademark at all, is when it's gone generic. So if you hear somebody talk about generic trademarks, there are lots of generic trademarks that we use every day. And it is a trademark, it is a brand that no longer operates as a trademark because it is used to describe the thing itself. A trademark is an adjective, right? So they're Nike shoes, they're Nike headbands, they're Nike watches. It's not a Nike. I'm going to wear my Nikes. You will never hear them say that because that's misuse of a trademark. That's using it as a noun. So when it starts, the trademark becomes the thing itself. It has gone generic. So aspirin used to be a trademark, right? It was actually aspirin brand pain relievers. Elevators. It was elevator brand moving stairs or motorized stairs. I'm sorry, escalator, not elevator. Escalator was a trademark. So motorized stairs, electric stairs, this sort of thing. Generic now. Everybody calls it an escalator. You might remember if you grew up, when I grew up, there was a jingle. I'm stuck on Band-Aid because Band-Aid stuck on me. Well, they were using their trademark as a noun. So they revamped, they amended their jingle. I'm stuck on Band-Aid brand because Band-Aid stuck on me, right? They had to fix that because they were running the risk of losing their rights in the Band-Aid trademark. They're actually bandages. They're sterile bandages, not Band-Aids. So if somebody asks for a Band-Aid, they're misusing the trademark, right? And that's why I think Johnson & Johnson owns that. They're always fighting losing their brand. Kleenex is another one, right? Kleenex almost, they had to fight hard to keep that brand because it's not a Kleenex, right? It's a facial tissue or tissue of some sort, but it is not a Kleenex. Kleenex is a brand name. And so it's a Kleenex brand tissue. So once it's gone generic, you can't fix that. It's dead. You've lost your trademark rights. So brand owners really try to protect them. So once you're filed, you get searched back and forth. That's trademark prosecution. Eventually you get a certificate of registration. Once you have your trademark certificate of registration, you own the trademark, right? You have a registration with the USPTO. You have the bulk of your costs as a trademark owner, year 1, 5, 10, 20, 30, 40, 50. So the bulk of your cost comes at the beginning to get it, to get through prosecution, pay all your government filing fees, pay all the different government things that are required. Once you get your registration at year 5, and there's a window, it's between 5 and 6.5 years, you prove that you're still using it. So you file an affidavit of use, and you can also request that your registration be deemed incontestable. Kind of a misnomer. It's not necessarily incontestable. It can still be contested. It's just the means and grounds by which you can contest it are very, very, very limited. Then at year 10, same thing. You have to say, hey, I'm still using this, government. You should still let me have my trademark. Let me have this registration. Let me have all these rights. Pay your fees there too. And you're good for another 10 years. So you have filings at year 1, year 5, year 10, and then every 10 years after that for as long as you want to keep the trademark. Infringement of trademarks. So this is a good one. What is infringement? How do you infringe a trademark? No one owns words in gross. You don't just own words and say, hey, I own the word Gimmick Attorney for everything. So I own it for shoes. I don't know why the hell anybody would want Gimmick Attorney branded shoes, but if they did, there's nothing I could do about it, right? It's my trademark related to legal services, now podcasting, I suppose. But outside of that, somebody else can use it. You probably have seen lots of the same named goods or services, but they're on unrelated things. So we're talking about the test of the similarity of the marks and the relatedness of the goods. Now, there's a class of trademarks that are famous. And being a famous trademark gets you very distinct rights, very important rights, because you can stop somebody from using a trademark even when there's no likelihood of confusion. So even on unrelated goods and services. To be a famous mark, that's called trademark dilution, if you've ever heard that term. To be famous, it's a pretty high standard, right? Disney, Coca-Cola, Walmart, things like that. Those are pretty famous brands, probably Ford, things along those lines. But McDonald's, certainly. But the local mom and pop shop, while it may be a famous pizza store in Toledo or Des Moines, it's not famous in the sense of kind of the federal dilution laws. So it doesn't get that special treatment. But if you've got a famous mark, this is all kind of, I don't want to say it doesn't apply. It does apply, but you also have rights and ways to protect beyond it. So the test, the similarity of the marks and the relatedness of the goods or services. So here's an image, a fun one, of the pandas, and one panda hitting another with a chair. I'm not going to go too in depth with the World Wrestling Federation versus the World Wildlife Fund. I'm hoping to do that as another episode of this, to go more in depth of how WWF lost the F, got the F out, if you will. But that's an example of the marks were identical. The relatedness of the goods or services, that's arguable. But if I remember correctly, that was fought in the UK, whose laws are pretty similar to ours. But the court found, there's confusion there. And WWF, World Wrestling Federation, you have to change your mark. How about Taz versus Taz? So ECW Taz had 1 Z, WWE, WWF Taz had 2 Zs, which is interesting because I think that the WWE kind of sold the bill of goods to someone. I'm not exactly sure who. I think they did it so they'd have their own rights. And they probably told Taz, well, there's 2 Zs, which is different. And so it doesn't count. It's not infringement. It's not true. That's very much infringing if Taz or ECW wanted to go after them and say, you can't use that name because it infringes my Taz 1Z trademark. Phonetics matter. So if your trademark is trucks with an S and I come along and I'm selling trucks with a Z, well, that's infringing. That is close enough. Even if you would say that, well, that's not a phonetic equivalent. If it's pronounced properly, it would sound different. That's fine. But the marks are pretty highly related. And if the goods or the services that I use with that mark are the same or related, that's infringement. How about rhino with an I versus rhino with a Y? Very same analysis, identical. That is a phonetic equivalent. That was probably infringement. WWE wanted to own something, and so they tweaked the spelling, but didn't want to change the name. So when I talk about similarity of the marks, relatedness of the goods, let's go a little more in depth in that. So Nike is the example I like to give. So Nike, these guys in the Northwest, they make shoes, right? Let's pretend that's all they sell is shoes and that are not famous. And I come along and I start selling Nike brand shoelaces. Marks are the same, goods not the same, but they're pretty highly related. I don't think it's crazy to think that a shoe seller would also sell shoelaces, right? Highly related, associated goods. That's infringement. Well, what if I started selling Nike branded shoe cleaner, right? Some kind of polish or something like this. A little further away, probably still infringement. It would not be crazy to say the source of these goods, the shoe company, is also a source of shoe cleaner. They often sell them together. Probably infringement. What if I started selling Nike branded car tires? What if I sell Nike branded spatulas? Is somebody likely to think that a shoe company sells tires or that a shoe company sells kitchen spatulas? Probably not. Probably not infringement. What if I wanted to start selling Gimmick Attorney shoes? I could do it, and Nike can't stop me. There, the marks are so different from one another, there's not a likelihood of confusion, even though the goods are exactly the same. That's why you can have Reebok and Asics and Converse and all these things, that they can all coexist and sell shoes because the brands are so different. There's no likelihood of confusion. That's the test, right? That's what we want to do is avoid confusing consumers and confusing them as to the source of the goods or services. So long as the marks are different enough, the goods can be exactly the same. So long as the marks are the same and the goods are completely unrelated, that's okay too. So what are some best practices with trademarks? Clearance search, clearance search, clearance search. I can't stress it enough. The attorney who trained me when I was coming up used to say, we don't want you to have to repaint your trucks. And it's kind of an outdated thing, but you get the idea. If you're printing all these pamphlets and doing website development, and maybe you do have some trucks or car magnets or whatever to advertise your stuff, you don't want to have to go back and redo it because you didn't clear the brand first. And you've got your customers and people that are used to a certain brand, used to seeing certain things, and now all of a sudden you've changed it. And maybe if you're lucky in a settlement, you get a certain amount of time to educate your customers, but you get a little bit of egg on your face, and all the goodwill that you built up in that brand, you got to throw away and start over. So clearance search, clearance search, clearance search. Police your trademarks regularly, use regularly, and use consistently. So if you've got a 2 or 3 word mark and you use hyphens, always use the hyphen. If you have S's and you start using Z's, don't do it. Use your trademark consistently because you want the goodwill to be built up in the trademark and the same trademark every time. And as I mentioned before, if you've got a registration, use the circle R. If you don't, use the TM. TM is free to use. It's okay to be wrong. If you think that you have trademark rights in it, you should use the TM on your trademark. Last but not least, the right of publicity. And this one's just as important as trademarks, if not more important, when it comes to celebrities in particular, but it also applies to private citizens. So what's the right of publicity? It's the right to prevent the unauthorized use of one's name, likeness, and other recognizable aspect of one's identity. So it's, again, your name, a famous person's name, a famous person's likeness, or a recognizable aspect of their identity. So some sort of hand gesture, perhaps, or the sound of their voice. There's a case with Bette Midler that someone came along and found spot on sounding like Bette Midler to do a commercial. Well, she sued and won because people thought it was Bette Midler. She had the right to control the sound of her voice and imitations thereof. How is it protected? Well, it's protected by state statute or by common law, which is kind of the courts and the history of the courts and decisions that have come along, or both. Can be both, but it's state by state. Each state has different laws, has different ways of protecting it, has different definitions. By and large, I think you're going to see there's pretty similar statutes and things from the states, but not all states have actually addressed this. We'll talk about that more in a minute. This is not to be compared. The right of publicity is not to be compared with false endorsement. And that falls under the Lanham Act, which is the trademark law, as you might recall. False endorsement is when you've created some sort of suggestion that that celebrity has endorsed your goods or services. There's a famous case with Woody Allen where he sued and won because they used a voice imitator, and it sounded a lot like Woody Allen, same kind of cadence and all of that. And that was found to be a false endorsement claim. He won. Vanna White won. There was a commercial. I don't remember what the product was, but they basically had this robot that had blonde hair and was in a pretty dress and was standing in front of a board and turning letters and whatever. I think it was the product name. And that was something that was such a recognizable aspect of Vanna White's identity that the court said, yeah, that's false endorsement. You're suggesting that maybe even robot Vanna White, that Vanna White is endorsing this. Slap on the hand. You're wrong. You've got damages. The right of publicity can be called something different. So again, some states will differ from others, but some states will call it the right of publicity. Others will say it's the tort related to misappropriation, and it kind of falls under the right to privacy. And so again, same sort of thing, but it falls under different parts of the law and how it's treated in the words you'll see. When I mentioned that states differ, there are a few important elements of where they differ and how they differ. So the nature and the extent of the protection can differ from state to state, whether it's protected by statute or common law or both. I mentioned that already. Whether there are post-mortem rights. So whether there's still a right of publicity after someone dies. California, for example, has a post-mortem rights of 70 years. So for 70 years after someone has passed away, a celebrity or so forth, the right to protect that exists for 70 more years. Other states it's 30, 40, so on and so forth. Whether the right can be assigned. So some states will say it's a personal thing that cannot be assigned. So my right of publicity, as worthless as it is, it belongs to me, and that's it. I can't assign it to anybody else. Other states, meanwhile, say, yeah, of course you can assign it to somebody else. You can assign it to a company. You can assign it to your family, your wife, or whatever you want to do. When it comes to the right of publicity, there's this sort of inherent tension that we'll talk about later between this right to protect your likeness, your name, your recognizable attributes, and the First Amendment and the rights of others. And again, we'll get into that in a second, but there's this inherent tension that you always kind of have to deal with. It's important to talk about, this is very timely, just this year, California passed some legislation, and that legislation said the NCAA member universities in California are forbidden. They are prohibited from penalizing student athletes who sign endorsement deals, agents, or with attorneys. So they said, NCAA, it would be against the law for you to penalize student athletes who sign an endorsement deal, who sign with an agent, who sign with an attorney, and attorneys often act as business advisors, sort of in an agent capacity. I do some of that. I've got some partners at my office that do that. It's very different from an agent, which is a very specific thing for the NFL and that sort of thing. I think there's unions and rules and all kinds of stuff that you have to go through. So California passed that legislation. That's interesting. A lot of times you'll see things start in California and kind of make their way east. They're very progressive with their laws. Not always does it pass east. This is one I think that probably will. The thing about this law is it's not operative until January 1st, 2023. So we're still about 3 years away from seeing that. It could change. It could be stricken. Who knows what will happen. But it's a very interesting law that will protect student athletes and their right of publicity. State of Connecticut has some interesting things that happen. Important, of course, because as you know, it's WWE's headquarters where they are as their state. So Connecticut as a state has not ruled on the right of publicity. Probably pretty shocking, considering all the famous people that have their basis in Connecticut. Famous people being anybody related to WWF or WWE, because all those contracts have a venue and choice of law provision that says this is all going to happen in our home court. This is going to happen in Connecticut. At the same time, it's not surprising because WWE covers this in their contract. Hey, we own the right to do this and to exploit your image while you're here and after you're gone, and videos and so on and so forth. So Connecticut does not have any statute that covers the right of publicity. The Second Circuit, the circuit where Connecticut is, has concluded that Connecticut would probably recognize the right of publicity, but it's going to be synonymous with the right of right of privacy and the tort of appropriation, and it's not a standalone sort of right or law. It's very unclear about Connecticut whether or not there will be post-mortem rights or not. That's something to be decided. There was a fun case in Connecticut where the rapper 50 Cent sued Rick Ross because Rick Ross sampled the song Into Club and used 50 Cent's name on his mixtape on Jim Ross Rick Ross's mixtape Renzel Remixes. 50 Cent lost. He lost, but it was not because the sample was used, his voice was used, his name was used. He lost because he had assigned and signed away all his rights in the copyright. So the court couldn't and wouldn't divide the copyright interest in the song, the performance of the song. Remember, that's something you can protect with copyright, is the performance of the song, which necessarily has to be his voice. You can't separate those two things. So because he had assigned away his copyrights and the copyright owner allowed Rick Ross to do this, 50 Cent lost. There's also another pretty well-known Connecticut case related to Jacques Cousteau, the explorer. He had, and this is important, transferred his rights of publicity and ownership rights to a company prior to his death. So before he died, he said, hey, company, have all these rights, exploit this intellectual property, exploit my right of publicity, go forth, make money, make money for my family, me, whatever. Subsequently, he died, of course. I think not too long after he signed that, maybe a year or so. He had an estranged granddaughter who said, hey, I'm going to make a documentary. I'm going to retrace granddad's steps in some of these shows and specials and things that he had done. And the company sued. The company that the rights had been assigned to, that Jacques had assigned to, sued the network or the documentary makers, saying, hey, you can't use his likeness. You can't kind of trade off of his things that are associated with him, where he went, and this images of him and things like that to make this documentary. And this was done in France because that's where Jacques Cousteau lived at the time of his death. And interestingly, in France, there is no post-mortem right. So you don't have the right to keep protecting after someone dies. But because Jacques had assigned it before he died, the company can't die. So the right lived on. So that's an important thing, at least in France, to think about. If you're famous, hey, before I die, we should put this with a holding company or someone else, because this Cousteau case has said, hey, my rights still exist. They still live. The granddaughter lost is the short story. And because he had a valid right, the right was with the company that should have been. They brought it in Connecticut. That's why there's the Connecticut tie, but applied French law. And so that was what came of that. Another fun place to talk about is New York, right? When people talk about WWE, they talk about it's the state of New York, or go up to New York and that sort of thing. And the state of New York, it's all statutory law. It's all done by statute, not necessarily by common law. There's actually a criminal cause of action in New York, so you can pay fines or do time. The government can go after you for misappropriating or using somebody's right of publicity. It's criminal when the description is, it's a cause of action for use of a name, portrait, or picture of any living person for advertising purposes or for the purposes of trade. There's also a civil cause of action, right? Just money damages. It's not brought by the government. It's brought by a plaintiff for the exact same definition, right? The unauthorized use of a name, portrait, or picture of a living person for advertising purposes or the purposes of trade. In August of 2020, New York expanded their post-mortem rights. So there was some after-death rights. It should be 40 years soon, so long as you lived in New York at the time of your death, but you must have died within 180 days after the law passing. So it's not going to look backward. It's going to look forward, and it has to be more than like 6 months forward whenever it gets signed into law. Interestingly, Governor Cuomo has not signed it yet, still sitting on his desk. So yet to be determined whether that'll happen. Probably will, but who knows? An interesting thing that happened in New York, I think it was New York, that's an interesting intersection between right of publicity and wrestling happened a few years back. There was Linwood Harrison. He's a former Philadelphia Eagles player. He's a former pro wrestler named Hard Rock Hamilton. And here's a photo of Hard Rock. So Linwood Harrison, Hard Rock Hamilton, sued Gears of War, the game. And Harrison claimed, Hard Rock Hamilton claimed, that Augustus Cole, a character in Gears of War, was based on him, in part because the character looked like him. That character, Augustus Cole, played for a fictitious football team called the Eagles, and he wore outfits that looked like Hard Rock's wrestling costume in his football uniform. So Linwood Harrison, Hard Rock Hamilton, claimed a violation of statutory and common law rights. And it was in Pennsylvania. I'm going to look at my notes. It was in Pennsylvania, not New York. So he claimed a violation of statutory and common law rights in Pennsylvania against Gears of War. Gears of War argued First Amendment protection. Nah, this First Amendment protects us. You can't sue us. So what was the decision? Well, the decision was Gears of War won. Surprisingly, the court relied on the transformative use test. So this test originated in California. Remember, I said that a lot of times things will start in California and move east, or courts and circuits will say, well, we haven't dealt with this. How have other folks dealt with it? And they will find somewhere that it applied and argue, hey, Pennsylvania, you should apply this law just like California applied this law. And they did. So they looked at the California right of publicity balance with the First Amendment. And what the court asked was whether or not the likeness is a raw material from which the work is synthesized, or whether the depiction or imitation is the very sum or substance of the work in question. So what the court found, and here's another picture, and it's going to pop up and it's going to show you a close-up of Hard Rock and Augustus Cole. The court found, well, yeah, there's a similarity in skin color and expressions, hairstyle, build, voice, sports interest, but there's significant differences that reveal Hamilton, Hard Rock Hamilton, was at most one of the raw materials from which Augustus Cole was synthesized. And the court found the biggest difference, if you can believe this, is that Augustus Cole, the Gears of War character, fights reptilian humanoids on the planet Sarah. And Hard Rock Hamilton and Linwood Harrison do not. So the court found, and I quote, if Hamilton was inspiration for the Cole character, the likeness had been so transformed that it had become primarily Gears of War's own expression. So it's basically a finding of, well, yeah, you were kind of the basis for it, but you're just one piece of this small puzzle of Gears of War, and one piece of this small puzzle that is Augustus Cole. We didn't sell Gears of War based on Augustus Cole. He's on all the materials, and we're really leaning into the fact that Augustus Cole was built from Linwood Harrison. Therefore, you're trading on it. You're actually trading on Linwood to get sales and make money. No, it's just a piece. Maybe it was borrowed from, maybe it was built from an actual person, but they weren't trading on it, and it was so transformative that it was a Gears of War creation and not Linwood Harrison himself. There have been similar findings, you probably know if you're a gamer, for Fortnite cases. So I think Alfonso Ribeiro sued him because the Carlton dance was a dance, and there's all kinds of different people. I think there's a jazz musician who sued, saying, when I'm up there playing the saxophone, I do these dance moves and I do all this stuff, and it's just part of my act, and people come to my show to see this act. And basically the court said, yeah, transformative use. Maybe it is based on some raw material that was you or this thing you do on stage, but they've done it in this virtual world where you're shooting and fighting and get respawned and so on and so forth. It's transformed so much that really it's an Epic Games, it's a Fortnite thing, not a you thing. So defenses, what are defenses to breaching the right of publicity, stealing someone's right of publicity, and it's okay? Newsworthiness is one. So it's kind of an extension of the free press, an extension of free speech, and it falls into the First Amendment. So if there's newsworthiness and something that the people want to see and there's a public interest in it, then it's probably going to be a defense. Matters of public interest is another one. So what's a matter of public interest? Well, a parody is a matter of public interest. We have the right to do kind of parodying things, and artistic works that are created, so doing paintings and that sort of thing, or creative works, those can be defenses under the right circumstances. Kind of fact intensive, as you can imagine, but it's potentially there. And also, you have to be, not everywhere, but in most places, your public identity has to be worth exploiting. So there were some movies where some character actors who, while they had been in certainly a few movies, they weren't, the Sean Penns and Harrison Fords. It was just kind of a bit part. And Galoob made some action figures based on this bit part character kind of in the background and used the person's likeness. And the court said, look, you're sorry, buddy, but you're not famous. There's really no value to your public identity worth exploiting. So no, you don't win. They didn't breach any right of publicity you have. So that's a potential defense. And that, my friends, is it in a nutshell. What are your thoughts? What are your thoughts on IP ownership and trademarks and things like that, right of publicity, especially in the wrestling world? What do you think about the territory days where guys own their trademarks before they went to a company and then after they went to a company? I think all the companies, at least the contracts I've seen, will have carve outs for guys who made it on the indies and have a name. And sometimes they get to keep those names, like in AEW, and sometimes they don't, like in WWE. Sometimes they do in WWE. But more times than not, and you probably hear it on all the AFS pods. And well, we changed that because that's something we wanted to own. It's not Kevin Steen, it's Kevin Owens. We want to own the name. We want to own the right. It's something we need to own so that we don't lose it and we can keep exploiting it and using it. And probably more importantly, keep you from using it and exploiting it. But what do you think about that? The carve outs allow guys to go in with a name like Carl Anderson and leave with the name Carl Anderson, because that's how he was known. That's how he came up in the indies. That's how he came up in New Japan. That's how he was in WWE. And that's now how he's known in Impact. So, Carl Anderson owns his name and has always owned it. And it was carved out in his WWE contract. Is it good? Is it bad? I mean, you tell me. A guy like Coco Beware is a bad example, right? He owned it before he went there. But Roman Reigns, right? If he leaves WWE, he's not going to own that name. He doesn't own it. It belongs to somebody else. He will have to go by Joe or whatever name that he would want to go by. Is that good? Is that bad? I would argue that the right of ownership that WWE has in some of those trademarks is challengeable, because they're not continuing to use it. They have archival footage on the network. And that archival footage, how's that any different than saying, well, I had a plumbing shop and you can still see my plumbing shop commercials on YouTube and you still see the trademark. Am I still providing plumbing services? No, I'm not. So my trademark isn't like it's historical reference, right? It's archival reference. In WWE, same thing. Are they still, using the, I'm blanking, but some guy who's not there anymore. Are they still using Viscera? Are they still using the Viscera trademark? No, of course they're not. And are they still using the Diesel mark and the Razor Ramon mark and providing wrestling services? No, of course they're not. It's all archival. And we've seen how poorly it goes when they try to get a different wrestler to take that moniker, right? Fake Diesel and fake Razor, that has just been mocked and lampooned and dumped all over since it happened, because it's a terrible idea, because the names, the trademarks are very closely associated with particular wrestlers, right? And so to say that WWE should own it, suspicious, questionable. I think it's challengeable. Maybe not for brands of shows and pay-per-views, because there's at least an argument that they're still providing that show, even if it's archival. But as far as a wrestler's name providing wrestler services, just because it's used on the network, I don't know about that. But it's going to take some money and it's going to take some moxie to challenge WWE on that and whether or not you would own it. But what do you think? I've laid out what I can, the best I can. I hope you took away from it what I was trying to get you to take away from it. That is the difference between patents, trademarks, copyrights, and right of publicity, and what all they cover. Let me know if you got questions. Let me know your thoughts. If you have questions, hit me up at Gimmick Attorney on Twitter, at Gimmick Attorney on Instagram. You can go to gimmickattorney.com, which will take you to my bio of the Shoemaker, Lupin, Kendrick law firm, and you can reach me through there. And for that, this is Mike Dockins. I'm signing off from another episode of Wrestling with the Law, and see you again next month.